slide. The next slide will highlight that you are able to connect with us regardless of communication methods. We're on LinkedIn, we're on Twitter, we've also independent through cipd.co.uk/Leicester. So please do keep in contact with us on different events that we may hold in the future. Go on to the next slide. So just for your own sort of housekeeping rules, your microphone will be muted. However, you do have the opportunity to put messages in the chat box. Please do introduce yourself. And if you have any questions relating to today's discussion, then please pop it on the chat box. There are a number of legal advisors available who will be able to go through those questions with you in due course. So the slides will be circulating, and I know a lot of people will be wanting to make notes, so you will get a copy of the slide. It is recorded, so that will be shortly available to you after. We do request that you complete a Survey Monkey just to keep up with if this is up to your standards of what you're expecting to sort of hear about, and if there's anything else further that we can support you on those matters. Just a few local events that are going to be occurring online, pretty self-explanatory. There's an event on Thursday next week on return on investment and data. We've also got the policy focus group on post-Brexit and labour skills shortage on the 4th of May. That's during lunchtime. Mental well-being, that is quite poignant, particularly as we're getting a lot of questions on mental well-being in the workplace due to the impact of COVID. So that's a pretty good one from a mental health perspective on Wednesday the 12th of May. The Leicestershire Independent Group meeting, 14th of May again, another one which is quite interesting. And finally, there is the Leicestershire branch annual meeting on the 14th of June, a little bit later on, covering the topic of sustainability and the role of HR within that. And finally, I'm sure you guys are pretty much inundated with a lot of things, but if you do go online, cipd.co.uk/member benefits, please be mindful there are a multitude of benefits available to you. If you are in a standalone role and you want further support in terms of specific queries, you can call the helpline. That's part of your benefit. There are a number of CIPD resources, including COVID-19 resources, which will be useful for you, particularly as we sort of continue in the pandemic. So there's a number of benefits extremely useful. So do have a look at that so that you're benefiting, including discounts on books, as well as any other sort of career support that you may wish to have in this field. So without further ado, I'll pass you through to Rena so she can start the presentation. And yeah, thank you very much.
Rena, you're muted at the moment.
Let me just get my technology right. Sorry about that. Thank you, Anu. So my name is Rena Magdani. I'm an employment partner at Freeths, and I'm joined today by my colleagues Emma Batten, Hermes Alton and Jake Holloway, who are all employment lawyers in our Leicester office. I just wanted to say thank you, first of all, for joining us today for the Employment Law Update. We really enjoy hosting these sessions for the CIPD. We have over apparently 250 people booked to attend today, which is really fantastic. I'm sure that as HR professionals that you've all had a very busy time over the last 13 months. And I think this is very much going to continue. So what we thought we would do today is cover some employment law topics that we think you'll find helpful as we come out of lockdown. So in terms of what we're going to be covering today, we are kicking off with COVID testing in the workplace. So Emma's going to be looking at whether you can require employees to have COVID testing at work and what the legal issues are around this. We're then going to be moving on to COVID vaccines and the no jab, no job debate. And Hermes will be covering the legal issues concerning this. And finally, we'll be looking at the legal issues around remote working or hybrid working, which we think is likely to be very much sort of a long-term feature going forward. And Jake will be considering the legal issues around this. So without further ado, I shall hand you over to Emma to kick off the topics. Thank you.
Hi everybody, and thank you Rena and Anoop and Eleanor. As Rena mentioned, I'm going to be talking about COVID testing today, and I think alongside the vaccination programme, this seems to be one of the key elements that the government are really focusing on to get us back to some kind of normality. And I think a lot of employers will probably be turning their thoughts to this at the moment, given that there's likely to be a large proportion of staff returning to offices, perhaps in the next couple of months. And likewise, there'll be a number of organisations that are already using a testing programme where they perhaps have a number of staff that aren't able to work from home. So it's a really important process to consider. And I think there are a number of key legal implications to think about before you implement a testing regime in the workplace. So the first question we've got there is whether it is a legal requirement, and the short answer is no. The government guidance acknowledges that it's very much a voluntary decision for employers to run testing programmes for its staff, but they do strongly encourage employers to regularly test their employees, obviously to reduce the risk of transmission in the workplace. So that scenario kind of puts employers in quite a difficult position, really. It's very much actively encouraged to implement a testing regime, but likewise, individuals are not under a legal obligation to consent to the testing programme. And there are various options for employers who are looking at COVID testing in the workplace, ranging from the kind of most invasive processes regarding kind of on-site mandatory testing programmes, right down to a voluntary testing programme whereby employees can take a testing kit and undertake it at home, which is seen as a much less invasive process from an employment law perspective. So it really is for businesses to think carefully about where they sit on this, whether they want to implement a process, and if so, at what kind of level they want to do it. And in terms of kind of proportionality we've talked about on the slide there, whilst there are very clear health and safety reasons and justifications for testing staff, ultimately it is an invasive process. The testing procedure is quite uncomfortable. I'm sure most of us have undertaken the swab at least once in the last couple of months. And employees may feel that it is unnecessarily invasive if they're not exhibiting symptoms, and where there are other ways, such as perhaps social distancing or PPE in the workplace, that could ensure that symptomless infection is not passed on to colleagues. So it's really important that employers weigh up the type of testing regime they're looking at and whether that is proportionate to the risks within their business. And it needs to be made clear as well that regardless of whether you implement a testing regime, that the other safety measures that you have in place, such as the social distancing, the PPE, the good hygiene measures, they still very much need to be adhered to. And Public Health England have made it clear that lateral flow testing alone is not going to be the silver bullet that kind of stops the spread of this. So looking at the kind of GDPR issues that are kind of associated with implementing a testing regime, if you are considering a kind of mandatory on-site testing programme in your workplace, you will ultimately be collecting special category of personal data, and you will need to have a good reason for processing this, because ultimately data relating to health is the most sensitive category of data. Now, the Information Commissioner's Office has provided some guidance in respect of this and how the GDPR sits alongside kind of rights of employees. And they have made it clear that as long as there is a good reason for implementing a testing programme, employers should be able to carry out health testing on employees, as data protection law doesn't prevent them from taking the necessary steps to keep their employees and the public safe during the pandemic. However, they also highlighted the fact that employers must be very careful that when they're handling sensitive category of data. So in terms of the kind of justifications that you would be looking at, so I think they're relatively common sense in that it's likely to be that it's consistent with the employer's obligation to keep the workplace safe, but also it's necessary for public health. But it's not enough to simply have a reason. It also needs to be recorded somewhere. Perhaps if you are considering implementing a COVID-19 policy, it may be that it's the appropriate place to set out that justification reason in that policy. And I'll come on to the kind of types of things that can be considered in those types of policies in a bit more detail later. In terms of GDPR, it's also worth flagging that you should be having a look at your privacy notices that perhaps haven't been looked at for a couple of years. I think it's fair to say that when they were drafted, nobody had in their mind that a business would be undertaking a testing regime on staff in the midst of a pandemic. So it's worth having a look and going back to those privacy notices to check that you're setting out clearly how employees' sensitive personal data will be used in that scenario if you are having on-site testing put in place. In terms of ACAS and how they are approaching testing, they again have some guidance on this, and they've set out very clearly in that guidance that if employers are wanting to test staff in respect of COVID, they should first be talking to staff or recognised trade union or other employee representatives. And those discussions should include around how the testing would be carried out, how staff would get their test results, the process to follow if there is a positive test result, the level of pay somebody would receive if they had to self-isolate and cannot work from home, how their absence would be recorded, and how the testing data will be used, stored and deleted in line with data protection rules. They also set out in their guidance that any decision after that discussion should be put in writing. So, for example, in a policy document, like I mentioned earlier. So if we can move on to the next slide. So how do you start this process? Well, our advice very much is in line with the ACAS guidance. And I think the key really is before you implement any kind of testing regime, you very much look to consult with staff or trade union or employee representative groups before you undergo that process. This type of process is likely to be much more successful if you are seen as doing it in partnership with your employees, and if both the employees and representatives understand the basis for why you are looking to implement this process, and that there is a kind of common goal there that both parties are looking to achieve. And in terms of the kind of issues to consider when undertaking this consultation process, again, we mentioned some of the topics that ACAS mentioned, but also look at who will be tested. So will it be all directly employed staff, or will it also include contractors or agency staff who perhaps work on site as well? And if you are including agency staff, do you need to have a look at your commercial agreements with your temporary labour providers to make sure that they understand what will be required of the staff that they're providing on site? And it also may be that they need to update their own documentation to comply with GDPR. How often will staff be tested? What test will be used? And again, how will the employer use those test results in a way that's compliant with the Data Protection Act and GDPR? As with any new process, communication and transparency really is key here. And certainly I think businesses would be best advised to seek responses from staff on the proposals before they're put in place. It will also allow businesses to see where the areas of concerns are, answer any questions that are raised, and to reassure and inform staff as to how the process will happen and how their data will be used. You should also be making it clear whether the regime that you're looking to implement is going to be voluntary or whether it's going to be mandatory, and the potential consequences of failing to comply with those procedures. And again, like we set out, or like I mentioned earlier, in respect of the kind of justification and the proportionality element of it, it's also really important to set out why the business considers it necessary to undertake these types of tests, and highlighting the fact that it's obviously designed to prevent the further risk of infection. Likewise, if you're a business that has a large number of employees in the workplace, perhaps because they can't work from home, or you're working with the public, or social distancing is difficult to adhere to because perhaps of the size of the business, then it's really important that all of those reasons and justifications are set out to start, so that they understand where you're coming from and why you're looking to undertake this process. And it's essentially just a really important comms piece. So make sure the communications you're having with your staff are really open and transparent, and you're answering questions and concerns wherever they're raised. And then following those discussions, it would be sensible to put a policy in place which sets out the basis for the testing regime, including the justification as to why you are processing sensitive personal data, as well as the practicalities of the testing process. And if you're implementing a mandatory testing regime, confirmation again of the implications if an employee refuses to comply with that. It would also be really sensible to seek explicit consent from employees to undertake testing, again assuming that's being undertaken on site. So if you do get somebody who is refusing the lateral flow test, is this firstly considered a reasonable management instruction? Well, I think most of us would probably agree that undertaking a test to ensure that you're not an asymptomatic COVID sufferer isn't an unreasonable request, and certainly I think that there's a strong argument to say that it can be justified by the risks of the health to other employees and perhaps members of the public, as well as the risks to the business if COVID spreads within an organisation and perhaps they have to close. However, it still requires employees to undergo an invasive and an unpleasant test. So I think there does need to be some thought given as to why it would be considered a reasonable management instruction. And certainly I have come across a number of organisations that have had a number of employees that have refused to undertake lateral flow tests. And it's happening perhaps more regularly than you would expect. And I think there's often a wide range of reasons as to why. It may be that employees are unclear as to what would be done with their sample or their results. There's perhaps a lack of understanding as to why it is necessary, and this might be particularly prevalent if you are a business that has a number of nationalities and languages spoke within the organisation, and perhaps there's been some things lost in translation there. And likewise, employees may not want to undertake the test simply because it's uncomfortable, or they don't feel like they should if they're not displaying any symptoms. So if you have an employee who is refusing to undertake a test, what can you do? Well, I think that the potential, again, assuming that it's been made clear that the testing process that the business is undertaking is mandatory, is potentially disciplinary action for failure to follow a reasonable management instruction. However, I would caveat this and say that it is very much a last resort. I think from an ER perspective, you would want to get to the bottom of why testing is being refused. You would be seeking to offer reassurance to an employee about any concerns that they have. And as I mentioned earlier, communicating with staff before any process is implemented would hopefully weed out any potential issues or grumblings that you have quite early on in the process, and it would assist in helping staff understand that this is for their benefit, and it is simply to try and stop the spread of COVID. Ultimately, though, I think if that has all been done and an employee has continues to unreasonably refuse to undergo testing, and there is very clear justification for a business in wanting to do this, then it may be that disciplinary action could be justified. But like I said, I think that should very much be the last resort. And certainly if you are getting to the stage of looking to dismiss somebody who has 2 years service, so has the kind of unfair dismissal rights, then it may be sensible to take some advice in respect of that, because there may be some legal implications as well. So I'll hand you over to Hermes now, who is going to cover off the legal issues in respect of vaccines.
Thank you, Emma. Thanks very much, and good afternoon, everybody. If you can please move on to the, oh, we have lovely, next slide, no jab, no job. So I'm covering the hot topic of vaccination today. This is one of the key questions of 2021, isn't it? To vaccinate or not to vaccinate? And you may have heard of the no jab, no job slogan, which has become popular in the media, and is what Charlie Mullins, the chairman of Pimlico Plumbers, had announced in relation to his staff. So, you know, it was a bold statement to make, and it raised questions of whether we should all follow suit. But I think I wouldn't necessarily suggest so, especially at this stage. And the reason being is that the government has not actually made it a legal requirement for the vaccine to be compulsory in any setting at the moment. And the ACAS guidance advises that employers should support staff in getting the vaccine once it's offered to them, rather than any sort of requirement to get the vaccine. And interestingly, the ACAS guidance previously acknowledged that employers may need to make vaccination mandatory where it would be necessary for an employee to do their job. And the example they gave was if they had to travel overseas and it was a requirement of the country of entry. However, this wording was removed in the latest update to the ACAS guidance in February of this year. So we do see a slight backtracking of ACAS advice in relation to this area as well. And I think that makes a lot of sense at this stage, because we are at an early stage in the vaccination programme, and there's so many contradicting news stories out there, including whether those that have been vaccinated can still transmit the virus, so the spreaders, as they call them, and whether certain vaccine types can actually protect against certain COVID variants. So this is likely to have a bearing on whether it is appropriate to compel employees to receive a vaccine when the research and evidence is not quite there yet, and there is definitely not the assumption that it's going to be 100% effective. Also, the current government advice is clear that vaccination is not a substitute for workplace COVID secure measures that Emma mentioned early on, which employers must continue to comply with, so social distancing, the PPE, hand sanitisation, etc. So what would be the potential risks of such a blanket requirement? Well, firstly, I wanted to highlight that there are potential discrimination issues, and mandatory vaccination requirement could amount to less favourable treatment in relation to those with certain protected characteristics. For example, where an employee is unable to get the vaccine because of a health condition, this may lead to arguments of disability discrimination, or, for example, if they have not been able to obtain a vaccine because of their age, or they're not suitable because of their age, this again may raise arguments of age discrimination. Another interesting area is, of course, whether certain anti-vaccine beliefs could be protected under discrimination legislation, and whether that could amount to a moral objection to the vaccination, which is protected, and could amount to religious or philosophical belief discrimination. And there are, of course, also possible risks in relation to sex discrimination, where, for example, pregnant employees or females who are trying to conceive cannot have the vaccine for those reasons. Another area of risk to consider is breach of contract, because introducing a contractual requirement for employees to have the vaccine would amount to a change in their terms and conditions, and that requires employee consent. So if employees who object to such a requirement refuse to consent, but as an employer we try to impose this change on them, the employee could resign in response to this as being a fundamental breach of their contract and claim constructive dismissal if they have more than 2 years service. If an employer were to terminate and re-engage the employee on the new terms of employment, this could still potentially lead to unfair dismissal claims. And really the test, it's the usual test of varying terms and conditions of employment here, where such dismissals will need to be considered, and the fairness will be considered in relation to whether it was reasonable for the employer to require the vaccine in the particular context, bearing in mind the particular roles in the particular organisation, and also looking at how unreasonable the employee's refusal might be in that context. And given that employees who object may have a range of reasons for doing so, and some of them, as we've highlighted, could be protected characteristics, forcing through a change for existing employees is likely to be risky. Of course, there might be special considerations which apply in the care sector where vulnerable individuals are concerned, and we'll come on to that shortly. Another area of consideration is privacy risks. So there may be scope to argue that a vaccination requirement is an unnecessary invasion of an individual's privacy, particularly when there are other less invasive ways to minimise the risk of transmission in the workplace, i.e. the COVID secure measures that we've been doing over the last year or so. Under the Human Rights Act 1998, UK courts are required, as far as possible, to interpret legislation in the UK in a way that is compatible with the European Convention on Human Rights. And it is unlawful for public authorities, which would include public sector employers, to act in a way which is incompatible with the Convention. So as a requirement to have the vaccine would likely be an interference with the Article 8 right to respect for private and family life, an employment tribunal and a public sector employer would need to carefully consider whether that interference could be justified. And the final area of risk that I wanted to touch upon is that there is always the risk of even a small number of employees having an adverse reaction to the vaccine. And therefore, there is a risk of personal injury claim. So if an employee is compelled to obtain the vaccine and suffers an adverse reaction, they may seek to bring personal injury claims as a result. So what about those workplaces where there is close contact with vulnerable people, such as in the care sector? Well, there may be more scope to argue that employees in the care or healthcare sector may need to require employees to be vaccinated, because refusal could put vulnerable patients at risk. However, at present, there is no legal requirement, and this is an untested area where such employers will need to proceed with caution. And I just wanted to highlight that currently there is a government consultation which is opened in relation to whether mandatory vaccination in the care sector or in old adult care homes would be permissible and something which should be imposed via legislation. And the reasoning behind that is because experts on the social care working group of SAGE advise that 80% of staff and 90% of residents need to be vaccinated to provide a minimum level of protection against outbreaks of COVID. And currently, only 53% of old adult homes in England are currently meeting this threshold. So this means that nearly half of all care homes with older adult residents don't meet SAGE's recommended vaccination thresholds for care homes and staff. And currently, the staff vaccination rate is below 80% in 89 local authority areas, which is more than half. And there are 27 local authority areas with a staff vaccination rate below 70%. So in view of these figures and statistics, on the 14th of April of this year, the government consultation opened on whether to make the vaccination a requirement for those working in the old adult care sector. It closes on the 21st of May, so about a month later, and I would encourage care sector employers to take part in this consultation. There are a lot of questions that form part of the consultation, but essentially the proposal is to require older adult care home providers to deploy only those workers who have received the COVID vaccination, but this wouldn't include those who could provide evidence for medical exemption. And the consultation considers questions like implementation of this mandatory requirement. So how would we find out or be able to prove that mandatory vaccination has taken place? Would it be via a mobile app? Would it be a self-declaration? Would a verbal confirmation be sufficient? It would also look at the impact of the proposed requirement on the ability to procure or commission care services. It also considers questions around the management of unvaccinated staff. So how would care home managers respond to staff that haven't been vaccinated? It also considers equalities issues and also the commercial impact. So would this create a negative working environment? Would it reduce staff morale, having to have this mandatory requirement in an already under-resourced sector? And whether staffing levels to maintain a safe service will be impacted if the policy is implemented. So again, strongly recommend that those in the care sector do take part in that consultation. So in light of these risks then, how best can an employer approach the issue of vaccination? Based on, as I say, the current state of play, and especially if vulnerable adults and individuals aren't concerned, it is likely to be fairly high risk to impose mandatory vaccination in the workplace. And a suggested alternative to introducing such a contractual requirement would be to introduce a policy of voluntary immunisation, which recommends that all employees who can be immunised should be immunised. Of course, this also fits in quite nicely with the employer's duty to take reasonable care of the health and safety of his employees and to take reasonable steps to provide a safe workplace and a safe system of work. And we would suggest that instead of potentially requiring vaccination, implementing a voluntary vaccination policy would be the more appropriate step to take at this stage. And employers who would like to implement such a vaccination policy should consider some of the very similar points that Emma raised in relation to testing. So, consultation with staff associations or unions before implementing the policy, how they intend to communicate with staff about the vaccination policy, how personal data will be used, of course, the data protection obligations that Emma mentioned in relation to processing personal data, how the policy could be used to reduce risk of potential workplace conflict between the vaccinated and the unvaccinated members of staff, and in what circumstances the policy would need to be reviewed. So, for example, as I say, it's a fast-moving area at the moment, so if private vaccination becomes a possibility, reviewing our policy in light of those updates. So a vaccination policy should address the following issues. So firstly, the purpose and benefits of vaccination. So explaining the purpose of the vaccination, which is to facilitate health and safety of employees and other third parties, and also to help an employer comply with its health and safety obligations. To provide information for employees on COVID vaccination and set out the employee's position in respect of related workplace issues. To encourage vaccination in line with public health advice, but of course acknowledging that this may not be a blanket recommendation based on individuals' specific circumstances, and also making it clear that vaccination is not a substitute for the other health and safety measures that we need to carry on implementing to have a COVID secure workplace. Also, the policy should confirm in a bit more detail which roles are covered. So, does everybody need it, or are there certain roles who should be advised more than others to have the vaccination, or certain workplace locations, and why there is that differential? Whether there are any circumstances in which the employer requires the vaccination, if there's, for example, travel abroad required, and also whether it extends to third parties that's also entering the workplace, not just our employees. Another area that's been suggested as potentially being of benefit or that might increase the take-up of vaccination is in relation to pay. So whether employers will give employees paid time off to attend their vaccination appointments, because currently there's no legal requirement to do that, but of course that might be an incentive for employees to want to take up the vaccination if they know they won't be penalised for attending their appointments. And of course, this should also cover the data protection angle and explain to the employee how their vaccination data would be used, how long it will be retained, and that, of course, that the employer will keep that data confidential. And I'll now hand over to Jake to continue with what's on the horizon.
Thanks, Hermes. Hi, everyone. Just before we sort of move on to sort of what's the future of sort of remote sort of hybrid working, I thought I would sort of cover, you know, in terms of just touching upon what Emma and Hermes have talked about in terms of sort of, you know, whether, you know, we can sort of justify sort of disciplinary action. So briefly just wanted to touch upon that in terms of the COVID secure measures that obviously we've all introduced or we've advised on. Clients introduced, you know, social distancing, you know, face covering, one-way systems, you know, obviously not attending work when individuals having symptoms, you know, obviously there will be justification where, you know, an employee does breach these secure measures that have been put in place. But obviously it's going to come down to, as it normally does, you know, what the employer does and have they acted reasonably in the circumstances. And that's, you know, crucial going to be, you know, how were these measures implemented? You know, were they adequately communicated to employees? You know, would the employees have known, you know, reasonably known that they were in breach by their actions? You know, what were the reasons why they didn't comply? Was it reasonable for them not to comply? You know, did they, you know, have any sort of health conditions that required them not to wear, you know, face covering, etc.? You know, and looking about, you know, is it a fact that, you know, as an employer, we could have done better, we could have made the employees more aware? You know, is it more of a training issue for ourselves, or was it a case that, you know, an employee has sort of willfully refused to comply with the measures that we've put in place to secure sort of a safe working environment? You know, also other considerations, you know, how severe was the breach? You know, sort of a minor breach of not sort of following a one-way system probably isn't going to justify disciplinary action, but, you know, attending work despite having symptoms, you know, obviously that's, you know, going to be the more severe end of the scenario. And also in terms of looking about, you know, what were the consequences of the breach? You know, that can include potential consequences, but also actual consequences as well. So it's all going to come down to, you know, it will be justifiable taking action, but obviously we have to be acting reasonably in all the circumstances in terms of ensuring that any disciplinary action that we do take is ultimately going to be fair at the end of the day. Okay, so I just wanted to obviously touch upon that, which is obviously covered briefly by sort of Hermes and Emma. So I wanted to sort of move on sort of to the main topic now, in terms of sort of hybrid and remote working, really. I think certainly we are going to see sort of, you know, and are sort of seeing at the moment a trend into people requesting sort of more sort of flexibility in sort of working environments, and, you know, businesses and industries that probably were a bit adverse to you know, the idea of individuals working from home have obviously seen benefits, you know, over the last 13 months, you know, in that sort of sense. And recent sort of things from Morgan Stanley, you know, they've said that nearly half their office staff are working in London 5 days a week from home. You know, PricewaterhouseCoopers have also said that, you know, 86% of UK bosses are seeing a long-term shift towards remote working. So it really is, you know, a hot topic in terms of, and one that, you know, employers should be looking at sort of addressing, and are going to be on the receiving end of certain sort of requests for sort of more flexible, sort of agile working. In terms of sort of obviously the benefits, you know, which are, you know, allowing sort of employers to, or allowing employers to sort of see that sort of benefits, you know, obviously savings from them in terms of overhead expenses. You know, we're getting sort of employees, we're getting a better work-life balance. Location independence, not only does it allow individuals to apply to for jobs which, you know, are not in their locality, therefore having a broader range of job opportunities, but it also allows employers the same in terms of having a wider pool of talent that they can choose from. You know, and also it increases, you know, it can increase productivity and performance. You know, we all know in office environments, you know, you do get, you know, lots of distractions, your general sort of chit chat, you know, just catching up on what you've done over the weekend. You tend to get less of that in, you know, from working from home, and also without sort of the commute, etc. You will find some employees will actually log on earlier and log off later, and actually, you know, you are getting a lot more, you know, increase sort of performance and productivity from them in that sort of sense. Can I have the next slide, please? That's great, thank you. In terms of firstly sort of flexible working requests, we're likely to see a lot of an increase in this area, and typically they can be informal requests where there's no sort of eligibility sort of requirement for an employee wishing to sort of vary their hours or change of place of work, and that is then down to an employer to agree if they can, you know, with the employee. But we also do, obviously, as you know, have the more formal statutory right to make a flexible worker request. And so that comes with eligibility requirements of 26 weeks service, and also not having made a prior application within the previous 12 months. But with these types of requests, even if they are informal or formal requests, we have to consider them in a reasonable manner. You know, we can only, for more the formal flexible working requests, we can only where there are limited numbers of the where we can refuse a request in that regard. Obviously, I won't go into that in too much detail now because we haven't got time of missing. But essentially, you know, we still be, when we are dealing with these requests, informal or formal, we are still bound by our general employment law obligations. You know, acting reasonably, not to give rise then to a constructive dismissal claims, but also not to discriminate on the grounds of a protected characteristic, and also considering other issues of discrimination in terms of, you know, are we under duty to make reasonable adjustments to someone's working environment due to them having a disability, for example. So there are a lot of considerations from that perspective that we will need to sort of address as these applications come in, really. In terms of sort of home working agreements, you know, we've certainly advised a number of businesses on in terms of making, you know, home working agreements, agile working policies, and using these to work alongside the more sort of formal flexible working policies. And it allows an employer to set out, you know, how they will deal with such home working requests, you know, what circumstances are they permitted to work from home, and what, you know, their expectations will be in terms of, you know, for example, you know, what staff members can, you know, obviously some more client facing may not be able to work fully from home, whatever, you know, what the supervision requirements will be, you know, how will the business monitor performance and output. So things like this are all sorts of considerations that will need to be placed in these types of policies, just to make sure that the employer knows what to expect of staff, but also the employees will know what the employer is expecting from that point of view. In terms of, you know, if we are, you know, agreeing to more a flexible, agile sort of working relationship, you know, in the future, there are various other considerations in terms of, you know, varying the contract of employment. If, you know, we are changing the place of work, then as we all know, the Employment Rights Act states that the contract has to state the place of work, and that includes whether that person is working from home or is office based, or what other places of work that they would be working from. And if there is a change in that, then we need to notify and agree in writing with the employee within 1 month for the change. So a consideration is then making sure that the contract is varied accordingly. It's all confirmed in writing, just to make sure there's no issues that arise later down the line. In terms of more of a consideration from a health and safety perspective, obviously, you know, employers have a duty to ensure the welfare and health and safety of their employees, obviously only as far as they can reasonably practically do so. But this obligation also applies to those working from home. So wider consideration is needed in terms of, you know, how can we assess any sort of hazard or risks that employees may face when working from home. And obviously that entails us carrying out employers carrying out risk assessments to identify these risks and, you know, what the degree of those risks are. For example, things like, you know, stress. How do we monitor, you know, individuals' working practices? You know, are they doing too many hours? You know, how can we still have that element, you know, of control in terms of and understanding in terms of what they're doing? You know, how will they be supervised? You know, because ultimately you can employees may still feel actually more isolated by working from home than what they would otherwise be working in the office. So these risk assessments from a health and safety perspective will ultimately, you know, identify any sort of hazard risks, and then as an employer, we need to be putting in place measures and procedures and to try and adapt the way of working and try and reduce those risks from occurring. In terms of all the ordinary sort of health and safety legislation, for example, display screen equipment regulations, things like that continue to apply to those home-based employees as it would do for people in the office. So we are, as an employer, we're not allowed to, to forget that, requirement just because they are working from home. That duty of care equally applies to those home-based employees as well. Moving on sort of to sort of GDPR issues, obviously, as we know that, we have an accountability obligation, and part of that accountability obligation is the security of any sort of personal data. So the personal data must be processed in a manner which ensures appropriate security, including protection against unauthorized and unlawful processing. So that necessarily obviously creates a lot of issues for employers and employees in terms of, for employers to make sure that their employees know what their obligations are in relation to data protection, and how that needs to be conveyed as part of any sort of home working policy or flexible working agreement. Certainly, as well as ensuring that employees are adequately trained on what their obligations are, employers should also be carrying out data privacy impact assessments, which impacts any sort of risks that they envisage actually by these individuals working from home. For example, who will have access to the employee's computer and personal data stored on it? Will the employee's home be left unattended for regular periods? If so, is the data properly secured? Any sort of remote working systems, is that encrypted? Is that password protected? All these things are going to need to be assessed, risk assessed, in order to ensure that you are complying with data protection principles and your obligations under the Data Protection Act. In terms of, obviously, it's generally more advisable for employees working from home, to use company issued devices, but that may not be always available, certainly for smaller sort of, family run businesses that may not have the ability to provide equipment in that sort of sense. So, we should also then be considering actually what do we need to do then to make sure that the data that is being processed, by these employees at home are adequately protected by security measures. So it may be the case where we have to then put sort of multi-factor authentication systems in place on personal laptops. So we need to be thinking about that area as well in terms of, how we best protect our data when it's being used on individuals' personal devices as well. One of the main issues that we sort of see is obviously with regards to employers is the resistance for sort of remote sort of agile working is, performance, they say performance is definitely going to decrease because we can't keep control over that. But that's easily combated by the fact that in any sort of home working arrangement, you should set out clearly what expectations are, and so that the employee fully understands them. What is it that you are sort of requesting productivity, making sure they're taking breaks, what the rules around if they become sick, etc. But also having it kept under, a constant review and making it clear that if an employee fails to meet those expectations, then the home working arrangement may be terminated. So ensuring that an employee knows specifically what it is that you expect from them by agreeing for that they can work, part at home or fully remote in that sort of sense. Obviously, in terms of performance, is also around how can we best motivate and manage, teams remotely. It's not very straightforward as it can be when you're office based. How do we need to look at training managers in terms of how they can manage their staff, remotely? It's different to being in an office where you're having, direct control and overseeing what they're doing on a day-to-day basis, but you don't get that when they're working from home. So there's an element of training of managers in terms of what their obligations are and how best they can combat, performance issues in that respect. In terms of, communication, we do need to have that regular communication. People can feel that actually, they're a bit more isolated, and they feel that they may not be able to raise issues. with line managers of things that they're experiencing. So therefore, you know, creating those effective line of communications is key, because obviously we all know, you know, if they're happy within the workplace, then the performance is likely to be, you know, good in that respect. So it's just creating, you know, an environment where creating those procedures and policies that you would create for the office environment, but, you know, mirroring that when, you know, you are dealing with home working employees. Similarly to GDPR sort of issues, you know, you've got potential considerations of protecting confidentiality. You know, obviously what in businesses will consider confidential will depend on the type of business and on what they carry out. But again, like with GDPR, employees should be made aware of their obligations, what you consider to be confidential, you know, and that should be made, you know, made known to them from the outset of the relationship. Obviously, home working environment doesn't lend naturally to secure sort of working and confidentiality due to sort of presence of, you know, family members, you know, friends, and the lack of, you know, secure sort of storage. So we need to be having considerations as to how best we can protect confidentiality, and that generally is sort of considerations around, you know, policies on, you know, if you're leaving your devices unattended, you know, locking them, making sure they can't be accessed, not disclosing passwords, not storing confidential information on personal devices without appropriate security on those personal devices, and also creating an environment where actually, you know, you encourage them to be reporting any sort of breaches of GDPR or confidentiality, because, you know, more towards the end of sort of more junior individuals, they may be reluctant to raise issue with a fear of, you know, being disciplined or not feeling confident in raising issues. So we need to sort of be creating that environment where we can sort of be raising those issues of breaches more freely. In respect of, you know, working time, obviously, you know, not being in sort of direct sort of control or having, you know, day-to-day, you know, overall sort of seeing of individuals, you know, lends itself to, you know, are we adhering to our obligations of the working time regulations by the maximum weekly hours in that sort of sense. And as an employer, we need to be taking reasonable steps to protect the health and safety and ensure that that working limit, if it's obviously not being contracted out of, opt out of, that we adhere to that. And things we need to be looking out for, you know, obvious signs of, you know, inability to switch off. Are people sending emails during the middle of the night? You know, we just need to be making more of a concerted effort to be looking at signs of actually people overworking and not adhering to the working hour limit in that sort of sense. You know, are we, you know, do we need to implement timesheets to record to make sure that people are sort of working their hours but also not working too many hours in that sort of sense? So we need to be considering, you know, the obligations on, you know, how much people are working, because it is, you know, easy. I think we can all agree that sometimes you think, well, actually I forgot to send that, you know, email, and logging on later in the evening to send that email, whereas actually you may not do that if you didn't have access to at home, or, you know, you knew actually, well, I was going to the office tomorrow, I'll just leave it till tomorrow. But so there is that ability for people to actually work longer by working from home. Like I said, they haven't got the commute, so we just need to be mindful of the working time from that point of view. I'm just conscious of time, so I'll quickly talk about the last two bits in terms of the provision of equipment. You know, are we supplying it? You know, staff will need appropriate measures, you know, equipment in place, i.e. desk, chair, you know, that sort of thing. So consideration needs to be given to the cost of those, and are we going to be providing grants, you know, for employees to buy certain equipment like a desk or chair to ensure that they are appropriately set up and able to work effectively from home. And finally, insurance. See, with the insurance side of things, we need to be looking at our current, you know, insurance policies, our clients' insurance policies, to ensure that they are fully protected. You know, does it cover, you know, employer liability insurance? Does that cover people working from home? You know, what about damage or theft of company equipment from somebody's personal home? Is that covered under the existing policy? You know, what about cyber-related breaches where we are looking at a breach that has occurred on a personal laptop that's being used for work purposes? You know, what is the insurance provision on that? So there's a lot of considerations with working, you know, from home remotely, or, you know, a hybrid working arrangement that we need to be aware of from that point of view. That is all that I wanted to cover. So I'll hand back to Emma now, and I think we're going to answer some questions.
Thanks, Jake. We've had some really good questions in the Q&A box, so have a look over that to see if there are any questions that have been answered that you have. Great interaction, so thank you everybody for participating in that. I think we've dealt with most of them. I've just got a couple of outstanding ones which we can quickly cover off. I'm conscious that we're getting close to the hour mark. The first one's probably for you, Hermes, because it's in relation to vaccines. Can an employer withhold sick pay from an employee who contracts COVID after refusing to be vaccinated?
Thanks, Emma. Well, I think the short answer is no. It would be risky for an employer to withhold statutory or contractual sick pay for an employee who's ill because of the vaccination, and that's purely because the reason why an employee has become ill doesn't affect the statutory entitlement to SSP. Of course, some contracts have contractual sick pay entitlements which are conditional upon certain things, one of which typically is if, you know, not paying out company sick pay if the sickness is as a result of recklessness or negligence, or, you know, when you participate in dangerous sports and that sort. But it's unlikely to cover a situation where somebody's refusing to have a vaccine done. Query, is that reckless or negligent, especially when the vaccine isn't 100% effective?
Thanks, Hermes, that's really helpful. And Jake, I've got one for you. If we allowed home working going forward, can we ask employees, can employees ask to work outside of the UK? It'd be lovely to sit on a beach and with your laptop in Barbados, but Jake, do you want to take that one?
Yeah, in terms of obviously whether or not to grant a request, it's going to be on a case-by-case basis, you know, taking, you know, what is the reason for the request, you know, are there any adverse implications of working sort of prolonged overseas? Certainly from my point of view, things that I would consider, you know, relevant points from an employment perspective, you know, employees of a UK employer will still likely be covered by employment, you know, UK employment rights, even if they're working in a different country. They also may then be governed by local employment rights. So that creates the added cost of getting, you know, any sort of advice from a lawyer in a different jurisdiction in respect of any sort of issues that may arise. Immigration status, you know, if they're not a UK national, then, you know, prolonged periods from the UK may affect their employment, their immigration status or right to work in the UK. So there's another consideration there that you may need to get advice on. Touched upon it previously, documenting the arrangement will still be the same in terms of making sure that any sort of changes to terms and conditions are, you know, agreed in writing. Also from a data protection point of view, depending obviously, you know, where they're going to be located, you know, you still have the obligations of the Data Protection Act if it's data for an individual that's within the European Economic Area. But if they're outside of that, are we then transferring data overseas? And is there any sort of requirements that we need to be adhering to making sure that we are fully data compliant? So there's those sort of issues. Again, insurance issues as well, in terms of, you know, do our insurance policies cover, you know, if an employee has an accident whilst they are, you know, working, you know, remotely abroad, things like that as well. So again, there's a whole host of, you know, issues, you know, to consider. So any sort of request, I think, you know, can be, you know, must be sort of taken on a case-by-case basis. But I don't see a reason as to why we can't. But, you know, we just need to be considering sort of the wider picture and all the issues that may come with that consideration.
Thanks, Jake. And then I think the last question we can kind of cover off is around the kind of lateral flow tests that are being undertaken at home and the implications for that. And I think if we are simply doing a voluntary process whereby employees can pick up lateral flow tests and undertake them at home, I think the kind of GDPR issues that I was talking about, that they're not going to be relevant here. It it is only if you are processing that data on site as part of an on-site testing regime. I think if it's just a case that they are being provided to the employees, they are undertaking the tests themselves, then no, that won't raise the kind of privacy GDPR issues that we talked about earlier. And I think that's probably all we have time for. If there are, I think we have done our best to answer most of the questions. It's been a really great session for question answering, and so thank you for everyone for that. But if there are any outstanding questions, as long as you've put your name to it, then we can come back to you separately after the session and respond to you about that. And I'll hand you back to, I don't know if it's Eleanor or Anoop to close, but thank you again for having us.
I think it's me, because I think Anoop had to leave before the end. But just thank you very much to everyone from Freeths, the team, for the presentation, and also for being on the case with the questions and getting all the questions asked and answered in the Q&A as well. So as I said, I'll be sending out the slides, I'll be sending out the recording, and we'd appreciate your feedback on the event. And thank you very much for joining us today. Thank you.
Thank you.